Hi everyone, Michael McVety here from Red Fortress Property Management. Just wanted to talk to you about a brand new major development legally in Florida for property managers, landlords, and tenants. Just wanted to cover that to you today. I hope you're having a great day. I'm Michael McVety, president of Red Fortress Property Management. I've been a property manager in this area, Southwest Florida, for 25 years and also a landlord. And I'm also the legislative chair for the local Property Management Association. I just wanted to cover Florida's new law on electronic delivery of notices or legal notices. So this new law has been signed into law. So there's no question about it. It is here. It just passed less than 2 weeks ago. And I wanted to cover a little bit more in detail. So basically, first of all, I'm not an attorney. Really, I'm not. I'm a property manager. But I did read the law itself and looked at a lot of legal analysis. And here's what basically the overview is that legal notices up until now were normally done in a certain way, like they were posted on doors, they were hand delivered, process servers, certified mail and postal mail. Okay, but based on the efforts, the very massive efforts of the Florida Apartment Association, the Florida chapter of NARPM, which is the National Association of Residential Property Managers, and also the law offices of Heist, Weiss, and Wolk, they worked at passing this law. They drafted this actual Florida bill and got it passed and signed by Governor DeSantis just recently. So this new bill is going to allow us to do electronic delivery, through email starting July 1st. Okay, so it's not in effect yet, but in less than 2 months it'll get into effect. Okay, so what does this actual bill do? So it's called the Florida House Bill 615. And like I mentioned, it's starting off, or it's allowed to go into effect July 1st of this year. Now, what it talks about specifically, just again on a higher level, is it talks about electronically delivering notices and that this requires an addendum, a very specific form and an addendum for the rental agreement. Okay, so you can't like sneak it into the lease somewhere or something like that. You can't. Okay, it has to be a specific form and an addendum. It also talks about how people can change their mind. So it's not only is it voluntary, but also at some point, if they've opted into it, they can opt out of it. Okay, and if they do, it doesn't change the history, which allowed emails to be granted the legal authority in the first place. If they say, "Don't send me these emails anymore for any legal notices. I want it done the other way," then that's fine. But it doesn't change the past. Okay, when it was legal to do so. How you go about voluntary changing the emails. Okay, so let's just say that if you don't want them anymore, how do you say to them, I don't want electronic emails? And also how to update a person's email. It could be the business, it could be the tenant. How do you go ahead and what exceptions do you have for that? Okay, so what it looks like in terms of legally, okay, is this electronic notices addendum talks about it this way, and I'll read it real quickly. It says basically, tenant election, okay, and this is right off the bat. Notices from a landlord or landlord's agent may contain time-sensitive information about a tenant's housing. The election to receive notices from the landlord or the landlord's agent by email is voluntary. Okay, now I put the bold there for my own emphasis. So again, this has to state right off the bat, it's voluntary. The residents do not need to sign this. It doesn't affect the residency in any way. All is good. So the first part says, I, so and so, the tenant agreed to receive notices required by the rental agreement or under the Florida statutes, Chapter 83, from the landlord or the landlord's agent by email. I designate the following email address for receipt of notices from the landlord or landlord's agent. So then they would fill this out at the time of lease signing. Or they can choose the second part, which says, I do not agree to receive notices by email. Okay, then it says, I may revoke my agreement to receive notices by email by following written notice to the landlord and the landlord's agent, which is effective upon delivery of such written notice and does not affect the validity of any notice that was previously sent by email. Okay, once again, greatly worded by the attorneys, very clear. I may update my email address designated for electronic delivery at any time by providing written notice to the landlord or landlord's agent, property manager, specifying the new email address, which takes effect upon the delivery of such notice. Okay, so it's instantaneous. Change my email you now have to abide by that. Okay. And there's also the same script for the property manager or landlord to do as well. I'm not going to duplicate it, but it's basically the exact same verbiage, and then people would sign it. Okay, so let's talk about the highlights of what this bill talks about. All right, so first of all, it talks about how you can cancel your email delivery method. So if you have it, and all of a sudden you say, you know what, this email thing isn't working out for me as a renter, I'm giving you it in writing, and I want you to stop doing it. It's immediate, it takes effect immediately, and all the past emails are still good, legally speaking. You just have to now, anything going forward, you can't do it by email. Okay. Also changing the email. Okay, so you notify the person in writing and it starts immediately. And there's lots of different reasons why people have their emails changes, like changing jobs, that sort of thing. That can happen. You see it all the time. As the email is sent, it is considered delivered unless it is returned as undeliverable. So you can see this sometimes if you type the wrong email address, there's a firewall. Sometimes it's a business email address and you have to do certain things to get through that firewall. So if you get something like that, that's really important. You're going to have to save that, okay? Because you can't just say that you delivered an email when in actuality it didn't, and you get notification, okay? Still maintain that the email was sent. So if you send an email off and it doesn't come and get kicked back, you still have to have a copy of that email that you sent to the tenant, obviously. Okay, you can't get rid of it. And the other thing is too that you need to know is that you can still deliver it the old way. So it's not an either you do electronic email of legal notices or we have to do it the old way, which is posting notices physically and that sort of stuff. You can do both. It's not an either or. Okay. So what type of notices does this cover? So again, most of the legal notices that you can possibly think of. So 3-day notices for non-payment of rent, 7-day notices with opportunity to cure, or 7-day termination notices, which are non-curable things. Security deposit claims and the security deposit claim notices. Those are that's a pretty big one there. A notice of intent to enter the premises, notices about security deposit account changes. So Florida law, if say for instance you switch bank accounts where their security deposits are located in, you have to give them legal notice. You do not have to give that legal notice though if your bank merged with another one. Okay, that's also in the law. Notices requiring tenant vacancy for extermination of pests. So if you had a situation where there was, something, I don't know, rats or infested a building or something, they all gone in there and you had to remove the renter or residents out of there, any type of legal notice, you can also serve it in this case. Agent or landlord address change. So if you're a property manager and say you move physical addresses, the legal notice that you have to give can be done through email if the renter chooses to receive legal notices through email. And then again, renewal and non-renewal notices, that's another big one that you could actually do through email should the renter choose to. Now, why would a renter and property manager choose this electronic delivery method? A lot of benefits. First of all, the time. So the property manager alone going to give out notices would save property managers and landlords a lot of time. It's also on the resident side too. Like if they have to give you legal notice that they're be not renewing their lease or something like that, they don't have to drive to your office either, or drive to some other location to give you a notification. Safety is a very big one. So when people are process server property managers, they're going to give a 3-day notice for non-payment of rent or any other type of legal notice, like a notice of entry or something like that. And listen, there's a safety side of things that's very, very important here. So when you're knocking on doors to say to somebody, hey, listen, are you there? You haven't paid your rent yet. Obviously, there's a possibility of danger of that happening. This would take that away tremendously. And I know that the residents also like the quiet enjoyment of their homes. So this way they don't have people like coming around their properties posting notices or knocking on their doors. Okay, there's no embarrassment side of things. So when you're posting a legal notice or any other type of notice, if somebody's coming by and slapping a notice that they're going to be in the area to look at roofs or something like that, again, as a renter or a homeowner, there's a certain social element that you don't want to be embarrassed that is, are other people looking at all these notices that are being placed on my door. So the email delivery would eliminate that. The confidentiality is there. It's between, say, your property manager and the renter. It's not, for the entire public to see with a posting of notices. It's also going to save a lot of costs. The driving, even the certified mail delivery. There was a case just last month we were returning a security deposit to one of our former residents. And, they called up after like 2 or 3 weeks and they said, we still don't have it. So we looked it up online, like it was a certified mail delivery, and it's just floating around somewhere in Lehigh. I don't know why it's floating around. There didn't seem to be anything wrong with the address that we sent the mail off to. It's just floating around. I don't know what they're doing with the mail, and this type of thing, again, it doesn't provide clarity. So the electronic delivery through email will provide a lot more clarity for people in those cases. So just a couple of final thoughts. As a property manager, again, there are a lot of things that you have to do. First of all, looking at things, how are you going to keep your email records? Okay. So, again, you might want to consider printing out certain emails, maybe for 3-day notices, maybe for non-renewal notices, maybe for 7-day notices with opportunity to cure. You might want to print them out and say put them in a tenant file if you have one. If a renter changes their email, how are you going to handle that? So, like for instance, you might be using a certain type of Microsoft Office where after you send Bob a couple of emails, it's automatically saved. Well, if Bob's email is saved and it changes, are you going to be, have the right procedures in place to stop that from going to the wrong email? Because again, it would no longer be considered delivered legally, going to the old email address when they notified you of the new one. Okay. Obviously, don't clear out your email sent folder. So, in other words, sometimes people are saying, "Hey, I'm coming up against the cap of space in my email, so I'm just going to go and delete all my emails that was from 10 years ago, and I'm just going to keep getting rid of all of them." You don't want to do that anymore, that's for sure, because you have no proof that you sent the email. Which notices are you going to do the old way too? So remember, it's not an either or. You can have renters choose to be notified electronically, but some of them you might want to still continue to do, like 3-day notices or a notice of non-renewal, because some of the renters could say, "Oh, I never got the email," and for like really important situations, is the judge in the case of say a non-renewal and you file an eviction because the tenant never moved out, is the judge going to say, well, you sent one email and, he didn't get it, so everything's fine? Or might the judge view that as a complication? So you might consider doing a hybrid method where you're doing, or both methods on key notices. Which email do you want your, renters to send their notices off to your company? So is it, through the admin at redfortresspm.com? Is it through the property manager? Is it through some other administrative person? How is it that you're going to do that? And if you have it go to one email address, who's monitoring and how do you disseminate that information throughout your company, right? So you have to think these things through as well for the best of what you think would work for your company. And then also, are there ways that you're going to promote this to the residents? So some residents will certainly love it. Other residents maybe not so much, or they don't understand it, or you know what, they're skeptical. They're skeptical of things like, oh man, that landlord or that property manager, they're probably going to do something to me that I don't understand yet. So I'm not going to sign it. So there's obviously going to be some level of education that has to go into this with regards to promoting it to the resident, and maybe there's different ways that you can do that as well. So keep in mind that this law, very well written, very clear. It's going to obviously have some situations where it might get modified over time by the judges, because the judges might say, hey, in this case, in this particular county, I don't think that one email was sufficient, or, do you have proof of it or that sort of thing? Obviously it has to be tried out in court, but really it's a benefit for both property managers, renters, and the landlords themselves. So it's a really good law. If you have any questions or comments, or email me at mike@redfortresspm.com. If I've said something that you think is, you want to talk about, or maybe another idea that I've just presented in final thoughts, great. Email me. We can talk about it, chat, and see how it might be beneficial to you, or just questions like that, so that everybody can get through this new law and do great things in the public era. So again, Michael McVety, President of Red Fortress Property Management. Hope this has been helpful, and we'll see you next time. Take care.